IA is for attachment before judgment, my lords.
Hmm.
My single contention is that the necessary parties are not necessary persons are not made parties in the suit, my lords.
Oh, the company is represented by the managing director.
Yes, my lords.
Managing director is the defendant in the suit.
Yes, my lords.
No, those issues as far as this are concerned.
Yes,
No, because the deceased, though they have made the parties and he is no more, will not have any bearing on that. These are admitted facts. You admit you have taken money. You said we are not now for a construction of a flat. Now you say no, we are not constructing the flat. We will refund the money or take somewhere else. He wanted refund of the money. You are not refunding. He filed a suit, and an attachment before judgment is passed. What's wrong? Is a defendant in the suit. The respondent herein, who is the plaintiff, had filed a suit for recovery of an amount of rupees 80 lakhs.
Yes, ma'am.
They learned that there has been serious interstate disputes between the partners, and the progress of the project came to a grinding halt, and they dodged them in execution of the agreement, giving two alternative options, namely either to take up existing flat at Sante, how do you spell it?
Santekatte.
Santekatte Udupi, are to take full refund of the advance amount. Plaintiff has opted for refund of the amount. The second defendant, through his mail dated 20/12/2019, confirmed that the amount would be refunded within 60 days, but thereafter went on dodging the matter on one pretext or the other. Third defendant, one of the partner, is no more. They would have brought the LRs of the defendant on record. Secondly, the civil court has no jurisdiction. It has to go before the commercial courts.
My lords, I'm appearing for petition in this matter.
Yes.
My lords, this is basically a time bar suit, my lords.
What is IA?
IA is for attachment before judgment, my lords. My single contention is that the necessary parties are not necessary persons are not made parties in the suit, my lords. They themselves agree. I am defendant number 2 in the trial court, my lords. I am one of the partner in the.
Please come to that order so that the court will
Yes, my
understand
lords.
what it is.
Page number 20 minutes.
Oh, it is attachment before
Yes,
judgment.
Yes, my lords.
Ah.
Which is bad in law because necessary
The court has
parties.
passed an order.
Yes,
Yes,
my lord.
Order 38 Rule 5.
Yes.
Yes, my lords. The property stands in the name of Mr.
We'll read the order.
Yeah.
What is it? Let's see the cause title. Where is the plaint?
The plaint is at page 29.
29.
29.
Yes.
Oh. The company, construction
lords.
company.
Yes,
And who is the second defendant?
I am second defendant, my lords.
He is the
He's
managing director.
He's
of
a
the
partner,
company.
my lord.
The partner
One of the partner, my lords.
And defendant number 3 is also a partner.
Is also a partner.
The next.
And Mr. Suresh Jattanna, who is deceased, was also a partner. And his name, the RTC shows, reflects his name and also defendant number 3's name, my lords. The legal representatives of the deceased are not made parties in this.
Oh, the company is represented by the managing director.
Yes, my lords.
Managing director is the defendant in the suit.
Yes, my lords.
No, those issues as far as this are concerned.
Yes,
No, because the deceased, though they have made the parties and he is no more, will not have any bearing on that.
but my lords, it is not just this, my lords.
No.
Kindly.
These are all admitted facts. You have taken his money and that money is lying with you. He wanted surety for it. You wanted to refund it. And first of all, filing an appeal against that order itself is an abuse of process. These are admitted facts. You admit you have taken money. You said we are not now for a construction of a flat. Now you say, no, we are not constructing the flat. We will refund the money or take somewhere else. He wanted refund of the money. You are not refunding. He filed a suit. And an attachment before judgment is passed. What's wrong? A surety of 80 lakhs which he paid. Please come.
My lords,
My
one
lords,
request,
the-
my lords. My lords, in the order portion, my lords, in the There is no direction, my lords, within what time stipulated the order must, order of attachment must be
In
made.
her petition, now this court would not
Yes.
clarify that.
Yes.
The,
My lords, the appropriate forum is commercial court, my lords, not the.
was it anytime,
No, that
Our
contention is
contention-
not even taken at in the written
an
statement.
attachment before judgment, no notice is to them?
My lords, they have filed an objection.
We have filed an
To that
objection.
Yes, my lords.
We'll leave it open to raise all your contentions
Yes.
there. The present writ petition is filed. Give the order passed in IN number. IN number 2 on the order 38 rule 5(1) A and B and section 94E and section 151 of CPC. The the respondent herein, the petitioner herein is a defendant in the suit. The respondent herein, who is the plaintiff, had filed a suit for recovery of an amount of rupees 80 lakhs,
Yes, ma'am.
recovery of an amount of rupees 80 lakhs. It is a case of the plaintiff that the defendant is a construction company and the petitioner had paid amounts for buying a what is it, an apartment or what?
Nissi Villa apartment.
Huh?
A flat in Nissi
Huh.
Villa apartment.
For purchasing a flat in the said in the said building. He had paid an amount of 32 lakhs 95,311 and which was confirmed by them through their mail dated 18/10/2019. And they periodically they used to get the progress reports of the construction. From 2018, there was no communication, and whenever they used to contact the partner of the first defendant firm, they used to give evasive answers and used to avoid. Later, they learned that there has been serious interstate disputes between the partners, and the progress of the project came to a grinding halt, and they dodged them in execution of the agreement. On 2012-2019, the second defendant sent a mail giving two alternative options, namely either to take up existing flat at Sante, how do you spell it?
Pantekatte.
Santekatte Udupi, or to take full refund of the advance amount. The plaintiff has opted for refund of the amount. The second defendant, through his mail dated 2012-2019, confirmed that the amount would be refunded within 60 days, but thereafter went on dodging the matter on one pretext or the other, which made the plaintiff to file the present suit. And in that, they filed this present application seeking attachment before judgment as it is admitted that the certain amounts are due. The amounts are due to the plaintiff. The court had passed an order. Aggrieved thereby, the defendant is before this court. Then counsel for the petitioner had the petitioner defendant had raised two grounds. One is that the third defendant, one of the partner, is no more. They would have brought the LRs of the defendant on record. Secondly, the civil court has no jurisdiction. It has to go before the commercial courts. Now the commercial courts, land counsel appearing for the respondent plaintiff submits that this is a fit case where an order of attachment before judgment is required. Unless and until such an order is passed, it would be difficult for the for the plaintiff to recover the money at a later point of time. And even if a decree is passed, they wouldn't be able to enjoy the fruits of the decree. Next para. Having heard the counsels on either side, there is the material on record. The admitted facts are that the plaintiff wanted to buy a flat constructed by the defendant, and in that regard, he has paid the amounts, and those amounts were also acknowledged by the respondent, by the petitioner defendant, and they have also gave an option to the plaintiff, the defendant, to the plaintiff that he can have a flat at some other place, or they will refund the amount, and that amount is not refunded. For all these things, there is evidence before the court that there is communication from the defendants. The defendants have filed objections to this petition filed under Order 38 Rule 5, and they have not, the issue of maintainability of the suit was not raised before the court below. Now, for the first time, the same is agitated. This court in a petition, red petition filed under 227, questioning, assigning an order of the court below, cannot go into those aspects at this stage, as such a ground was not raised before the court, nor and there was no occasion for the court to give any finding on that. And the court has rightly allowed an application filed under Order 38 Rule 5, and this court finds no reasons to interfere. The maintainability of the suits and all those issues are always open for the defendant to raise before the court below.